How to Avoid the Four-Headed Monster of Estate Planning and Elder Law, Patrick Kelleher on Amazon. Oh, hey there, folks. Elder Law Care Attorney Patrick Kelleher. Folks, today's question is, what are the big steps when it comes to estate administration, which can comprise of probate administration after a loved one passes away? What do you do? How do you do it? What are the steps? Or trust administration if somebody has a trust or a treasure chest and they pass away. You're the trustee, you're the fiduciary, you're a beneficiary. You may be curious, what are the steps? Well, pull up a chair, get your notebook out, because I am going to teach you today what the steps are of estate administration, whether it's trust administration or probate administration, or oftentimes a combination of the two, a hybrid. Folks, the acronym that I created so you can easily remember what the big steps in estate administration is the following. E.A.T.T. That's right, E.A.T.T. E stands for estate. A stands for assets. T stands for taxes, the tax man. The next T is transparency, good communication with loved ones. And the third and final T is transfer, the transfer of assets out of the treasure chest, disbursements, distributions to the beneficiaries of record in the will, in the trust, or if there's no will or trust, if it's by ways of laws of intestate in your state. So folks, let's break it down. E.A.T.T. The big steps of estate administration are, number one, E, open the estate. Depending on what kind of estate it is. Is it a probate estate? How would you know that? Well, if there's no trust involved and you have a copy of your loved one's will, and then that will typically needs to be filed at the local probate court, and you need to get someone appointed as the executor, personal representative. If there is no will or no trust, then you still have to open the estate, and you typically have to petition the probate court and have someone appointed as the administrator, executor of the estate as well. Okay, so that's with a will or without a will. And then if there's a trust, if your loved one has a trust, you have to open a trust estate administration. Okay, so you're going to have to work with a skilled, experienced elder law attorney or estate attorney to assist you with the probate process, whether it's a will or no will, and with the trust administration process, because there's a lot of steps that go along with those procedures and processes. Okay, second letter in our acronym is A. Assets. It's your job, once you're appointed as the personal representative, executor, administrator, or if you're the trustee fiduciary of the trust, it's your job, really, really important, to take your pen out, your notepad, roll up your sleeves, your calculator, and do an asset inventory. Marshal all the assets of the estate, then take a look at all debts and liabilities of the estate as well. Really, really important to get your head around all the assets of the estate and ascertain what is a probate asset and what is a void in probate as well, and what follows under the umbrella of the entire value of the estate. Another important component or part of the assets is capturing the date of death value of each and every asset. Why? Because the next letter in the acronym, T, taxes, the tax man. The taxing authority is often interested when a person passes away, because we have a thing called the estate tax. There's a federal estate tax, and then some states, there's 12 states in the country that still have state estate tax. So the taxing authority is going to be interested in the valuation of the assets on the date of death of your loved one. So really, really important that you work with your loved one's financial professionals. Really, really important to get copies of their statements and look at the date of death value, and it's really important that you calculate the date of death value and then work with your estate elder law attorney to find out what your obligations may be as far as taxes. Typically, with an estate administration matter, there's requirements to file final decedent return, which is Form 1040, personal income tax return of the decedent when they passed away, to put the taxing authority on notice that your loved one is no longer going to be paying taxes, and their social security number should be taken out of their process and out of their system. Then you have the 1041 form as well. That's if the estate has earned enough income of assets within the estate, typically $600 per or more in the estate account. And then the big one is that M706 estate tax return if it's a taxable estate on the federal estate tax or if it's a taxable estate on the state estate tax in your specific state. The next T, transparency. Really, really important. We already talked about the legal, technical aspects of estate administration, but this T here, transparency, from my experience, good communication, really, really important that you communicate with your loved ones regularly and consistently. Let them know what's going on, preferably in writing. Let them know you're doing a good job. Let them know the steps in the process, and set expectations how long this could take. This estate administration process, it can take months, sometimes it can take years, depending on how many moving parts, what is going on with other family members in assets and so forth. And let them know that. Set the expectations, good communication, good transparency, good respect with all, give all beneficiaries, loved ones, a voice in the process as well. Finally, folks, the last T is transfer. After you've paid all the taxes, after you communicated well with all the parties, after you worked with your state and elder law attorney, and you marshaled all the assets and taking care of all the liabilities and debts and so forth. Now it's your job to read the will, read the trust with your state elder law attorney, and make proper distributions, transfer of ownership, transfer of the assets as the inheritance. Follow the methods of distribution in the will, in the trust. Oftentimes there'll be specific instructions in there how those assets should be transferred and distributed to the beneficiaries. Really, really important that you pay attention to the terms and conditions of the trust or the will, how that beneficiary should receive that asset, okay? For example, if there's a family bloodline trust in there, you don't want to just give them a check payable in their name individually or personally, because now they're not availing themselves to the asset protection that was created in that trust. Another example, if the person or beneficiary is a minor, you cannot give a minor under 18 years of age a check. Another example would be if that person is incapacitated, disabled, on government benefits, then you cannot give them a check either. That money preferably should be going into a special needs trust with a trustee to manage the money for their benefit. Folks, there you have it. Hopefully you found this video helpful. If so, post a comment, post a question, and a member of our Elder Law Care team will get back to you as soon as possible. If you'd like to learn more on how to slay the metaphorical four-headed beast of estate planning and elder law, pick up a copy of my book on Amazon, Patrick Kelleher, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law, or go to elderlawcare.com to learn more. Folks, thanks for joining us today at elderlawcare.com.